All right, just to do some We the People news. Okay, I'm not an attorney. You know that. You also know that everything I say or do is just hearsay. Just take it with a grain of salt. Even these videos I do, if you don't do your own research, it's hearsay. Excuse me. So, the number one problem that everybody needs to recognize is we all been keep walking straight forward. So, quit doing that. Never walk straight forward. Always look around you. Be able to protect yourself by any means necessary. You know, if you don't pay attention, you're going to step off a curb and not know it's there. Then you're going to bust your butt. Okay? So always look around you. Use that Second Amendment. Arm yourself with knowledge. This is actually interesting, y'all. Because, like I said, we always got to look up definition words. And this is one of them that I didn't really look up. So it's like, well, that's it. An interesting video to watch. And again, I'm not an attorney, not giving legal advice. Okay, educational purposes only. Let's find out what this one word. Okay, matter of fact, it's gonna be facts. All right, no pun intended. But it kind of coincides with Title One U.S. Code, which is USC. Okay, Section 1. The number one thing on the codified. Up means down, down means up, side means, east means west, west means east. Boy means girl, girl means boy. That's the reason why we are all in the state of confusion today. What a boy is and what a girl is. Okay? Because of this code. Sorry, y'all. All right. But it ties in to the word facts. What is the legal meaning behind facts? Let's go.
I want to talk to you about a word that lawyers use a lot and has a very different meaning for us than it does in...
All right, so go to his channel, watch it, give him a thumbs up, okay? Because this is really educational.
common usage, even though it's a very common word. And that word is facts. We have a definition of the word facts that is inherent to the entire legal system and that we don't really explain to anybody else. And it's a little bit complicated, but it's really important to understand a lot of things about the law and logic and some other stuff. So I'm going to explain it to you now, or do my best. And even if you don't get it right now, as we go through some other things, I may send you back to watch this again. I don't know how many of you have seen My Cousin Vinny, but I'm just going to give you a quick overview real fast. Okay, the important part of My Cousin Vinny, real fast. You got a convenience store. Our two guys, the two Ralph Macchio guy, pulls up in a 1964 metallic mint green Buick Skylark. They pull up to the store, they walk in, they buy a couple things, they leave. Boom, done. Then, a couple of minutes later, two other guys pull up in a 1963 Pontiac Tempest that is also metallic mint green. It's basically exactly the same color, and it looks almost exactly the same. They pull in, they go in, they rob the place, and leave. And that's where the confusion happens. Meanwhile, you got this witness who lives nearby. And she's standing there. She looks over just in time to see the metallic mint green 1964 Pontiac Skylark pull in. Look, it's a 1964 metallic mint green Pontiac Skylark. But then she looks away. So even though we know that the Pontiac Skylark leaves, she doesn't see that. She also doesn't see the 1963 metallic mint green Pontiac Tempest pull in. So she looks away for a second, and she sees the same car still sitting there. Two robbers come out, drive away. She doesn't even know they're different people because the cars look the same. So the whole plot of the movie is that our two good guys in the Buick Skylark get confused with the two bad guys in the other car and have to go to court to prove that they didn't commit the robbery. But when that witness in the little orange house is brought in, the witness has to explain what they saw. So what happens if the witness says, I saw those two boys pull up in that green car, get out, walk in, and then turn around a few minutes later, walk out, and drive away. And we know that the robbery occurred sometime in that time period. Is the witness lying or telling the truth? This is where we find a new word to be useful, because truth is not going to cut it here. But neither is lie. So lawyers need a word for those little pieces of the story that we cannot know objectively if they're really true or not, but without giving them any sort of value judgment, we can at least say whether we're going to accept them or not accept them for our set of events. And that word that we use is fact. To a lawyer, a fact is a tiny element of the story. It's not necessarily.
And right there would be technically, because of everything of the circumstance, would actually be probable cause. Okay? So even though this may not be all in general true, where the judge would have to go with it, okay, there's enough here to be probable cause. Okay?
Necessarily true or untrue, because as the example of the lady in the orange house showed,
which goes, beyond reasonable doubt, by the way.
Sometimes you can't tell what's really true and not true in a courtroom. Often it comes down to what somebody's perspective was when they saw the event. But over the course of a court case, we take all of these little elements and decide which ones are going to be accepted into our storyline of events and which ones are not. And of course, all of the facts lined up make a fact pattern. The decision whether or not to accept a particular...
Now, I do like the word he used, because I'm going to extend another video to it about a story, okay? And it has to do within law, which is really interesting in itself, for me.
event as a fact may come down to whether or not the person who said it was believable. Maybe it's somebody with really thick glasses who doesn't look like they can see very well. Maybe it's somebody who seems to have memory problems. But somebody is going to have to decide which of these facts are going to become part of our fact pattern and which ones are not. That person is known as the finder of fact. And in most court cases, the finder of fact is the jury. In a few cases where there is no jury, a judge will stand in as the finder of fact. And in the end, the finder of fact will lay out a list of events that occurred in that particular parking lot. And those events will be...
Which in general, it'd be the prosecutor lining all this out. But you still got to really listen to the prosecutor. Because again, where's these trickery of words? How's he swaying you? And all that kind of stuff.
Known as the fact pattern. It's really up to the finder of fact to decide what the facts were and what the fact pattern is. Because only certain courts are allowed to find facts. Other courts are not. In most cases, higher courts, like a circuit court or Supreme Court, is not allowed to find new facts. Facts are found in the lowest level courts, in the district courts. And once a finding of fact is made by the finder of fact, once the jury decides that this is what happened, usually those decisions cannot be questioned. I know you've heard of appeal.
And this is the reason why, one of the reasons why, rebuttals are very important. Deny is very important. And objections are very important. Okay? So...
But appeals are only about laws, not usually about facts. That's not always true, but it's often true.
And I explained one time with the ticket with an officer, right? It was a dusky day, seat belts matched my uniform and all that kind of stuff. And then I asked the officer, is it possible that you cannot see the ticket due to the alleged work uniform being the same color? And the officer says, well, it's possible. Well, that gave reasonable doubt.
in the case of my cousin Vinny, the fact pattern was going to be that our heroes drove up in their metallic mint green car, went in and robbed the place, came back out, got back in their metallic mint green car, and left, because that's what the story the witnesses were putting together. The finder of fact really had no choice but to put that story together. And in the story, Marissa Tomei flies in right at the end and saves the day. She notices that the tire pattern of the getaway car after the robbery didn't match what the tire pattern would have been on the boy's car, our hero's car. So there had to have been two cars. So that piece of information changes what the finder of fact decides at the end is going to be the fact pattern. Now, if you made it all the way to the end of this, which God bless you, I hope you understand that part of the reason I'm explaining this is that we're going to talk about courts of appeals and the Supreme Court, which are not allowed usually to deal with questions of fact. And I needed you to really understand what a fact was.
All right. Which enhances, I am led to believe, and do believe, but I'm not an attorney, not giving legal advice. Hearsay purposes, educational purposes only. All right, for you to think outside the box. Okay. So, truth that I'm innocent. Okay. Facts is not guilty. Then false is guilty. Okay. Now, 1 and 2 can comply with one another. If you lie, then obviously you're guilty. But you can speak truth and still be guilty, saying, hey, yeah, I did do it, so I go ahead and plead guilty, right? But you spoke the truth and you commit. So the facts does not apply, okay? So you'd be guilty because you told the truth, but you could also be innocent because of the truth. The facts itself is putting you in a category of not guilty. And what they're saying is Title 1, U.S. Code 1, all right, is up can be down, down can be up, east can be west, and west can be east, right? That's the facts pattern. Everything is not what it seems to be. Okay? But I'm just speaking out my butt. This was a last minute thing, and I was planning on doing another video of something else, and this came up. Alright, this will be the People News. Till next time, bye y'all.